All right, welcome again. So today we're talking about the issue of pure economic loss in relation to buildings and chattels. We're not dealing with the pure economic loss that relates to the Headley Burn type cases, just buildings and chattels. And in this regard, a recent, I think it was May this year, a decision of the Ontario Court of Appeal came out that's very useful for our purposes. The decision's called North and Bayerische Motoren Werke, but by BMW, the car maker. This is a really interesting case, and I thought it would give me a chance to talk about the issue. Most of the litigation in this area has concerned buildings, but this case involved a chattel. It involved a car. And so I think that variation on the standard fact pattern actually helps us to understand what's going on in cases of this kind. So what happened in the North and BMW case is that the plaintiffs had bought a car and they claimed that it had been negligently constructed, negligently designed. The detail doesn't matter, but the claim was that there was a problem with the, make sure I get this right, with the timing chain in the engine that caused problems and it was going to lead to damage to the engine. So either had caused physical damage to the engine or would cause physical damage to the engine if it wasn't repaired. And the plaintiffs obviously were unhappy about that. It was an expensive repair, and they claimed that they had suffered property damage as the result of the defendant's negligence and so wanted to recover for that loss. And the Ontario Court of Appeal says, no, you can't recover for this, and what's more, it's not property damage. It's economic loss. And so what I wanted to do is talk about why that was, because on the face of it, it seemed both of those conclusions might seem a little bit strange. So on the one hand, the idea that it's economic loss and not property damage, that might seem very strange because, I mean, after all, there is, or at least would be, if the timing chain wasn't repaired, physical damage to the engine, right? So it seems that the plaintiffs are undeniable. The plaintiff's claim is undeniable when they say that this is physical damage. It's damage to our property. But that was rejected by the court. Why? It seems odd. The other thing is there's nothing unforeseeable about any of the loss that the plaintiff suffered. So one might think that on the ordinary principles of the law, the plaintiff should have succeeded, but the plaintiff failed. So why was that? What's the position here? What's going on? Well, I think that, as usual, the way to first get your teeth into this, the way to get a grip on this is to just think of a very simple case. Cars, especially modern cars, can be quite complex, and this will relate to an issue that we're going to talk about later, the complex structure theory. But let's just put all that aside for a minute and pick something that's really simple. I mean, I just got a cup. So here I have a cup, right? Which there are always cups sitting on my desk, so I tend to think of cups. I tend to reach for a cup to explain these things. Okay, so just imagine, right, that I've bought this cup, right, and then you come along and you negligently damage it so that it now has a crack in it, right? Can I sue you for the damage to the cup? Now, I have a cup, and maybe let's say it's a bad crack and the cup's now worthless. And let's just say, for the sake of argument, the cup was worth $10. Okay, you come along and you negligently damage it. You put a crack in it so that now the cup is worthless. I can't use it anymore. Can I sue you for the damage to the cup? Can I sue you for $10? And of course, the answer is yes. Well, why is the answer yes? Well, the reason is because the reason, I mean, there's a number of reasons, but the key reason for us is because I have a right to this cup. It's my property, right? And when you negligently damage it, you violate my right to the cup, right? And so I have a claim against you. Now, to relate this to a video I've made earlier, imagine that this isn't my cup, but is my wife's cup, right? I don't own it. My wife owns it. You come along and damage it. Can I sue you? No, I can't sue you because it's not my property, right? I have to have a right to the cup to ground my claim against you. Now, in the case we're imagining, it's my property, I can claim against you, that's fine. Okay? All right, now, change the case slightly. Imagine that it's not the case that I own the cup, right, and you come along and damage it, but rather the cup is already damaged before I buy it. Okay, so let's imagine that the cup is sitting in a store, right, sitting in a shelf. And let's say it's been negligently constructed, it's been negligently manufactured, and so it's got a crack in it already, right? And I buy the cup, right, and I take it home, and I discover that it's got a crack in it, right? And so it's useless. I can't use the cup, right? And I've just wasted $10 buying a cup that isn't any good. Now, we all know that there are certain things that I can do about that. For example, I'm very likely to be able to sue the person who sold me the cup for breach of contract, because it would at least be an implied term in the contract that the cup was, suitable for doing things that you do with cups, right? That would at least be an implied term in the contract, so I would be able to sue the person who sold me the cup. Also, there are various statutory regimes that exist throughout the world. So in this country, for example, certainly if the cup was new, I'd be able to sue under our Consumer Guarantees Act, right? The person, that is, I'd be able to pursue the person from whom I bought the cup and perhaps others under the Consumer Guarantees Act. But we're not interested in that. We're not interested in contract. This is not what we're talking about. We're not interested in contract or statute or these various statutory regimes here. We're interested in tort law. What I've said is that why does the cup have a crack in it? The cup has a crack in it because it was negligently manufactured. Can I sue the manufacturer for the crack in the cup? The answer is no. Why is the answer no? All right, this is crucial, and this is absolutely important. Really, if you understand any of this area of the law, it's absolutely crucial to understand this point. The reason that the answer is no is because I bought the cup with the crack in it, right? So I only ever had a right to a cracked cup, right? It's totally different than the first case. In the first case, I have a right to a cup without a crack in it, and you come along and damage it. You come along and crack the cup. That's a violation of my right to the cup, right? You putting the crack in the cup violates my right to the cup. But in the second case, because there's a crack in the cup when I buy it, right, I only ever have a right to a cracked cup. Okay? Now, I don't think this is actually all that difficult, right? So I think this is a pretty simple point. And the reason that it becomes difficult is we tend to forget the obvious things when we start thinking about things in a legal context, right? All the simple stuff just goes out the window and we think it's unsophisticated or whatever. But we need to remember the simple stuff. If I buy a cracked cup, I have a right to a cup with a crack in it, right? And the crack being in the cup is not a violation of my property right to the cup, because that's what I have a property right to. I have a property right to a cup with a crack in it. Okay. Now, of course, the crack might spread, right? That is, I might buy the cup and there's a little crack in it, but over time the crack spreads. That's still not a violation of my property right to the cup, because what I bought is a defective cup, right? I bought a defective, maybe this is a mug, whatever. I bought a defective, let's just stick with cup. I bought a defective cup, right? And when the defect starts materializing, that's no violation of my property rights to the cup. Okay, now, so this is really fundamental. This is fundamental to understanding what's going on here. Why did the court in North and BMW say that there was no liability? The fundamental reason is that on the plaintiff's own assertions, the plaintiffs bought a defective car. They bought a car that was defective. So when that defect materialized, that was not a violation of their property rights to the car. They may have, it looks like they don't, but they may have some other avenue of redress against the defendants or against somebody else through statute, through contract, whatever. But they have no, it seems that they don't, otherwise they wouldn't be pursuing this action. But in principle, they could have. But they certainly have no claim in tort, because the defendant's alleged negligence was not a violation of the plaintiff's property rights to the car. The plaintiffs bought a car with the defect about which they are complaining. And this also explains why the defect is characterized as economic loss and not property damage. I mean, nobody is denying the fact that the timing chain, the defects in the timing chain can cause physical damage to the engine. Nobody is denying that, right? Nobody is denying the physics. The point is that it doesn't count as property damage in the eyes of the law because it's just the property that the plaintiff bought deteriorating, right, in accordance with the defect that it has. So it's not a violation of the plaintiff's property right to the car. Similarly, and I buy the mug and there's a crack in it and the crack spreads, that's not a violation of my property right to the mug. That's just the defect materializing. Okay, now this is a really important, it's a really simple point, but it's a really powerful point, and it explains cases like, as always, the citations of these cases are down in the notes. Brentwood and Murphy and Brentwood District Council and other cases that are very important in, say, English law, but it also explains why if we're just talking about Canadian law now, where this case North and BMW came from, why there's been something of a retreat from Winnipeg construction, as you could see in the case of Maple Leaf Foods, where the Supreme Court said they're going to have to revisit Winnipeg construction. Why is there a retreat? Well, there's a little bit of a retreat, not a complete retreat, but a little bit of a retreat from that, because you need, as the court in Winnipeg did not recognise, you need to recognise that when you buy a defective product and the defect materialises, that's not a violation of your right to the product. Right? You have a right to have a property right to a defective product. Right? The defect materialising is not a violation of your rights to the product. Okay, now, it's really important to recognise that the reason that the loss is economic and not property damage is not because the damage has not occurred yet. I mean, this is something that people sometimes say. I know there's too many knots in that sentence, but let me give you an example. People sometimes say in cases like Murphy and Brentwood District Council, the reason that the loss was economic and not property damage was because the physical defects had not yet materialized. They were going to materialize in the future. That's not it at all. Right? The reason that the loss is economic and not property damage is simply because it did not result from the violation of the plaintiff's property rights in the object. Property damage is a violation of your property rights. Right? Personal injury is a violation of your right, as we call it, the right to bodily integrity. Okay, in North and Bayerische Motoren, in Murphy and Brentwood District Council, there was no violation of the plaintiff's property rights, so the loss is characterised as economic loss. Okay, and the court says this in North and BMW. They say this at paragraph 28. They make the crucial point. They say, the common law imposes liability for negligent interference with an injury to the rights and bodily integrity, mental health, and property. There is no general right in tort that protects one from the negligent or intentional infliction of pure economic loss. And to be sure, recovery of pure economic loss is the exception and not the rule. So they're basically buying in to the position that I've been advancing in this video and in previous videos. Okay, there has to be a violation of the plaintiff's primary rights in order for there to be liability. In these cases, the plaintiff does have a primary right to the object in question. There's no question that plaintiff owns the object. But the defect materializing is not a violation of the plaintiff's rights because the plaintiff only has a right to a defective car, defective building, whatever it happens to be. Now, another matter that's discussed in North and BMW is the so-called complex structure theory. And this is the idea. It was floated by Lord Bridge in a case called DF Estates, a decision of the House of Lords, that maybe the plaintiff could recover if the object that was about which the plaintiff is complaining, the object that's causing loss, has a complex structure. Okay, and unsurprisingly, because plaintiffs are trying to gain recovery, this idea has been very tempting. There's always been appeals to this idea since, and the plaintiffs in Northern BMW do appeal to this idea. They say that, look, a car is a complex structure, and cars are complex, right? They are certainly modern cars. They've got computers in them, and I used to spend a lot of time repairing an old Peugeot 504 I had when I was about 18. I spent a lot of time repairing it. I just couldn't even go near a modern car, right? They are very complex structures. And so you might think, okay, well, if the plaintiff can succeed when it's a complex structure, this is a good case to try out this theory because cars are complex structures. Now, the court doesn't buy this argument, and it's really important to see why. There's 2 paragraphs from the court's judgment, and one I think is much more helpful than the other. The first paragraph is paragraph 47, where the court is talking about the decision of the certification judge. This is basically the trial judge, the first instance judge. They say so this is from, did I say, paragraph 47. They say the certification judge did not accept that the timing chain system in this case was a separate system that is independent from the whole in which it is situated. As the plaintiffs had argued, as he said, it is self-evident that the timing chain system is not something that has any function outside of its place as a component of a larger whole. He also noted that the defect lies in the chain assembly system, a core part of the engine that is crucial to the operation of an internal combustion engine. Okay, so the argument was, look, cars are a complex structure, the engines are a complex structure, the timing chain is one thing, the pistons, or do the cars still have pistons? The pistons are something else. The carburetor, if cars still have carburetors, is something else. And maybe the fact that the defect in the timing chain was going to cause damage to another part of the engine means that this is a complex structure and the plaintiff should be able to recover. And as the court reports here, no. Now, the problem with this analysis is it makes it sound as if the way to settle whether there is a complex structure here or not is to ask the mechanics. I mean, there was all this, from the stuff I read out, there's all this stuff about, how the timing chain fits in with the rest of the engine and so forth. So the way to solve this is to ask the mechanics. It's a factual matter as to whether we're dealing with a complex structure or not. But that's not right. To think this way opens a huge can of worms. Like, for example, what is, if we're going to think this way, we have to answer questions such as, what is the difference between a complex and a simple structure? How do we distinguish between complex structures and simple structures? I mean, it seems to me there's no real way to do that. I mean, you might think that cars are complex and, I don't know, to just nick the example from Donahue and Stevenson, bottles of ginger beer are simple. But actually, there's quite a lot of complexity in ginger beer. Ginger beer is a complex chemical structure, right? And it's quite complex to brew. And I mean, it's not incredibly complex to brew, but, and anyway, if we're talking about how complex does something have to be to count as a complex structure, it just doesn't seem that there's any answer to this question, right? I mean, it's a bit like asking how long is a piece of string, how heavy is stuff? There's no answer to this question. We're just flying blind. A structure is complex if you want the plaintiff to win, and it's not complex if you want the plaintiff to lose. That's all you can say, right? So it just seems totally arbitrary here. And another thing is, why would it be the case that you can sue for complex structures, but you can't sue if it's a simple structure? What difference does it make whether the structure is complex or simple? Why should that make any difference? And on the face of it, there's no answer to that question either. Okay, but the proper way to understand the so-called complex structure theory is in terms of what we've been talking about already. That is, we're not really interested in how complex the thing is, so how complex the car was, or how complex a house is, or how complex a cup is, right? We're not Then we're not interested in any of that stuff. What we're interested in is whether the law perceives the object as the object of a single right or as the object of a multiplicity of rights. So in the case of the car, the issue is, well, let's start with the cup. With the example of the cup, the issue is, as far as the law is concerned, right, when I own the cup, what do I own the whole thing? Is that one right? I have one right to the whole thing? Or do I have one right, say, to the body of the cup and a separate right to the handle of the cup? Right? Well, the answer is that I own the whole thing. So there's one right. It's a simple structure, right? In law, not factually, we're not talking about the facts here, right? We're talking about in law. The law regards it as a simple structure. It's one thing, right? So when the crack materializes, right, it is not a violation of my right to that one thing. Well, what about a car, right? Is a car a simple or a complex structure? Well, of course, mechanically, it's a complex structure, right? But in law, it's not a complex structure. It's a simple structure. I don't have one right to the engine and one right to the seats and a separate right to the tires, right? I own the whole thing. That's one property right. I own the whole thing. Now, of course, I can separate things out. So I could take a wheel off the car and sell that, right? But that's different, right? You can do this. You can divide your property rights, right? But as the car is, I own the whole thing. I have one right to the whole thing, right? So I can't, I can't say that in law it's a complex structure because I have one right to the entire thing. It's a simple structure in law. I own the whole thing. And that's the same with a house. Houses are, maybe they're not as complex as cars physically, but they are still quite complicated things. But I have one right to the whole thing. I don't have a right to the roof and a separate right to the walls and a separate right to the floor. I have one right to the whole thing. So if I buy a defective house, right, and there's a crack in the cracks start appearing in the walls and that spreads to the roof, that's not a violation of my rights. I bought a house with a defect and the defect is now materializing. Now, why is this important? Well, let's go back to the cup. Let's say I buy the cup and it's got a crack in it. Now, let's say I don't know that there's a crack in it. And what I do is I fill the cup with boiling hot coffee and then the cup falls to pieces and the coffee spills and burns me. Right? Now, what I've said is that I cannot sue you for the cup, right? But I can sue you for the damage to me. I can sue you for my burns. Okay, not in this country because of our accident compensation regime, but as a matter of common law principle, I can sue you for the physical damage to my body. Why? Well, because I have a separate right to my body, right? And you putting out a cup on the market that is defective, a cup intended for use for containing hot liquids, right? And I use it for its intended purpose and it breaks and that burns me. That is a foreseeable violation, not of my right to the cup, but of my bodily integrity. Okay? So now this we might say is a complex structure. There's the cup and there's me. We could regard this as one thing in a certain sense, right? But it's a complex structure. What does a complex structure mean? It just means that there are at least two separate rights here. A right to the cup, a right to my body. I can't sue for the damage to the cup, but I can't sue the manufacturer for the damage to the cup, but I can sue the manufacturer for the damage to my body. And if you think about it, you already knew this because this is just Donoghue and Stevenson. Okay, and Donoghue and Stevenson made Donoghue could sue David Stevenson, assuming that the facts were as she said they were. She could sue Donoghue and Stevenson for her gastroenteritis, but she couldn't sue David Stevenson for the fact that she had a defective bottle of ginger beer. Right, she had to pursue that in contract, which she couldn't do because she didn't have a contract with anyone. Okay, all right. So if we could say that the plaintiff in Northern BMW had a property right to the timing chain and a separate property right to the other parts of the engine, it may have been possible to have argued that the plaintiff's property in the other parts of the engine were violated by the defendant's negligence, right? But that's not what the court just rejects that, right? Because the court says, no, you own the whole car. When you bought the car, you bought a defective car. You didn't buy a whole bunch of individual things, a defective timing chain and a well-constructed pistons and well-constructed tyres. And you didn't buy all those separate things. You bought one thing, a car. Okay? Now, you can see the court saying this in paragraph 48, the paragraph after the one I read out earlier, where the court gets this spot on. It's ultimately, the certification judge concluded that it is evident that neither the vehicle nor the rest of the N20 engine, that's the type of engine that the car had, were other property with respect to the timing chain system. In other words, this is not a traditional negligence claim, but rather a claim for pure economic loss. What matters here is whether the timing chain and the rest of the engine were separate pieces of property or not. They weren't, right? So therefore, no recovery. Exactly correct. Now, this is the complex structure theory then. The idea is that if the structure is complex, you might be able to sue. And the reason for that is that there will be separate rights in play here. So just to give you another example, if the cut breaks and it damages my clothes, all right, the spilling of the liquid damages my clothes, I could sue you for the damage to my clothes because I own my clothes. It's a separate property right? I don't have one right to my cup and my clothes. Right? If that was the case, we would have a simple structure and I wouldn't be able to sue you. But we have a complex structure here. It doesn't really help to think this way, right? It's always best just to think in terms of the rights of the parties. But this is the idea behind the complex structure theory. It's a complex structure here. I have one right to the cup and a separate right to my jumper here, right? So if as a result of your negligence, the cup breaks and it damages my jumper, I can sue you for the damage to the jumper. That's the so-called complex structure. As I say, it's always best just forget all that crap and just focus on the parties' rights. I have a right to the cup, right? But you didn't violate my right. I bought a defective cup. Right, I have a right to my jumper, right? But you caused this jumper to be stained. I didn't buy a stained jumper. You caused the jumper to be stained, so I can sue you in negligence for that. Okay, so the complex structure theory is actually not complex. It's a simple theory once you focus on what's actually important. As all of this is, it's all simple once you focus on what's actually important. What's actually important are the rights of the parties. All right, cheers. Thanks for watching. It'd be great if you could give a like or subscribe or leave a comment or whatever. But I hope this has been useful. All the best. See you again.